5 seconds to go. Start. The appellant has filed the present appeal against the judgment and order dated 22nd June 2012 passed by the High Court of Judicature of Andhra Pradesh at Hyderabad, hereinafter referred to as High Court, in Criminal Appeal number 811 of 2008, whereby the High Court has dismissed the criminal appeal and upheld the judgment dated 4th April 2008 passed by the Court of Sessions Judge at Guntur, hereinafter referred to as Trial Court, whereunder, the appellant was convicted for the offence under Section 302 of Indian Penal Code, 1860, hereinafter referred to as IPC, and was sentenced to undergo imprisonment for life and also to pay a fine of Rs 500 and in default to suffer simple imprisonment for 3 months. Stop. Para. Briefly, the facts relevant for the purpose of this appeal are as follows, para. On 6 September 2006, the deceased, father of PW1 and PW1 went to the 14th mile center of village to sell their vegetables. Stop. While PW1 was getting the vegetables weighed, the deceased crossed the road and went to the shop of PW3 to purchase tobacco leaves. Stop. PW2 and PW4 were also present at the place of occurrence. Stop. Having seen the deceased, the appellant, armed with a knife, came to the shop of PW3 and sprinkled chili powder into the eyes of the deceased, and stabbed him on the chest and abdomen, resulting in grievous injuries. Stop. The appellant immediately fled from the spot after seeing PW1 to 4. Stop. The deceased was taken to the government hospital Amravati, where the doctors declared him dead. Stop. Para. On the basis of the aforesaid report given by PW1, PW7 registered the case being FIR number 120 of 2006 dated 6 September 2006 at PS Amravati for the offence punishable under Section 302 IPC. Stop. Thereafter, PW8 and PW9 visited the place of occurrence, held an inquest over the dead body of the deceased, examined the eyewitnesses, arrested the appellant, and filed charge sheet against him. Stop. On 26 December 2007, charges under Section 302 IPC were framed and the appellant pleaded not guilty and claimed trial. Stop. Para. In order to substantiate the case, the prosecution examined 9 witnesses and there was no oral or documentary evidence adduced by the defense side. Stop. Para. The trial court, after analyzing the statement made by the prosecution witnesses, white judgment and order dated 4th April 2008, held the appellant guilty of offence under Section 302 IPC and sentenced him to imprisonment for life. Stop. Para. Being aggrieved, the appellant filed criminal appeal number 811 of 2008 before the High Court, challenging the trial court's order of conviction and sentencing. Stop. White judgment and order dated 22nd June 2012, the High Court confirmed the judgment of the trial court and observed that there is no iota of doubt in the case of the prosecution and therefore, the prosecution had discharged its burden in proving the guilt of the accused for the offence under Section 302 IPC beyond a reasonable doubt. Stop.